The evidence at trial proved beyond a reasonable doubt that this is a tormented and disturbed woman who will go to extraordinary lengths to wreak havoc upon other individuals, potentially subjecting them to life imprisonment in order to gain sympathy and notoriety for herself. Her story about the sexual assault in Santa Ylen County in September 2012 was suspect from the very beginning. Two men whom she recognized, although she had not seen in over 20 years, gained access to her home at 8 in the morning, perhaps with the keys she presumes was given to them by a family member. She is tied down and brutally raped and tortured for more than 2 hours. She chose not to report this crime to family or friends for several days. A friend observed what appeared to be bruising. It was still present a week or two later, and then she insisted that she inform the police. When Sara indicated that she doubted that the local police would believe her, her friend insisted that she make a report to the St. Clair County Sheriff. Although she made the report to Santa Ylen County Sheriff deputies, the interview took place at the St. Clair County Jail, which is why this case ended up in this court. Sara gave descriptions that were so detailed that the interview went on for hours. There were so many specific recollections of the minute-by-minute events that the investigating officers became immediately suspicious. She told the detectives that she had gone to Port Huron Hospital shortly after the incident and gave them a release to obtain a report. However, the hospital confirmed that she had never been seen or examined at that hospital. The detectives requested that she have her bruising and lacerations inspected by the county medical examiner. The lacerations barely broke the skin and appeared to be more recent than the time claimed for the assault. When the doctor attempted to clean the wounds that were reported to be 2 weeks old, the bruises were easily removed by washing them with a gauze pad. The doctor left the examining room to inform the detectives and returned with them to find the bruises had miraculously reappeared. In question, she challenged them by telling them they could search her purse to see that she didn't have any makeup with her. Though not in her purse, the search of the wastebasket revealed a makeup kit. Nonetheless, the officers felt obliged to follow up with their investigation. Nothing at the home had any evidentiary value. Bedding and clothing allegedly involved was bundled and brought to the police. There were no signs of blood or stains. No evidence of forced entry, even though Sara insisted that she had locked the door after having returned from dropping her kids off at school. The next step was to contact the alleged assailants. Kevin Patton is a social worker with the Community Mental Health Department. Records of that morning indicated that he was part of a weekly office meeting that lasted the entire morning. His presence at the meeting was confirmed by the director in the minutes of the meeting. Terry Stone is a partner in a construction company. Email communications and other office records attested to the fact that he was in his office miles away all day. Both of these individuals are mature men, well respected in the community, whose only connection to Sara Ylen is that her ex-husband belongs to the same church, Jehovah's Witnesses, the church to which he is trying to bring their children over her objections. At this point, the Santa Ylen County Sheriff decided to seek a warrant making a false report of a felony and tampering with evidence, that is, the concealment of the makeup kit. Venue was proper in St. Clair County since that is where the report was taken. However, the St. Clair County prosecutor recused himself in his office as they had prosecuted a case over 10 years ago in which Sara Ylen was the alleged victim of rape in the parking lot of Myers store. Although there was a conviction in that case, the case was reversed by the Michigan Supreme Court this past year because the jury was not informed of an alleged false report in California that occurred after the alleged rape but before trial in Michigan. The case was assigned by the Attorney General to the Wayne County Prosecutor's Office. The California incident came into evidence in this case under MRE 404B. For about a year prior to Sara's alleged sexual assault in Port Huron, she had established by internet phone conversations a relationship with a woman in California who headed a rape victim counseling service. In September 2001, Sara traveled to California with her husband and parents to visit relatives. One day that month, Katina Amagonian, the woman whom she had established contact with, received a call from Sara. Sara claimed to have been sexually assaulted in the parking lot of a restaurant and asked them to come and get her. Katina and her boyfriend, Mick Burrow, immediately drove 2 hours from their home in Fresno to Bakersfield to pick her up. She asked to be taken to their home, which they agreed to do. On the way, she asked to stop at an ATM machine. She insisted that Mick accompany her, but he refused to leave the car. The next day, while at work, as a crime scene investigator with the Fresno police, Mick Burrow was informed that the Bakersfield police were looking for him and his girlfriend in reference to a complaint of kidnapping. Sara had called her husband and father and told them that she had been raped and she had been abducted and was being held in their Fresno home. Mick called Katina and informed her of the allegations. Katina confronted Sara, who simply rolled her eyes back and said, "Sorry." Katina described the look on her face as maniacal. Mick then realized why she wanted him to accompany her to the ATM. He would appear on camera and she would have manufactured evidence to support her story. Sara continued to assert that she had been raped in Bakersfield and she couldn't believe her bad luck, as she had just been raped in a parking lot of a store in Michigan a month before. However, she indicated to the police that immediately after the rape, she had gone into the restaurant and had lunch with her family, but didn't mention the assault. She had no explanation as to why she claimed to have been abducted, other than she was under a lot of stress. No actions were taken by the Bakersfield police, but Mick Burrow insisted that a report be made preventing future claims against them. He believed that if he had not been a police officer, he would have been arrested. Deliberations were not long. Sara Ylen was found guilty as charged with filing a false report of a felony and tampering with evidence of a criminal case punishable by more than 10 years. But the portrait of Sara Ylen is not yet complete. Earlier this week, she appeared in the circuit court in Sanilac County and pled no contest to various charges, including larceny by false pretenses of $20,000 to $50,000, healthcare fraud, and use of a computer to commit a felony. These charges stem from her claims of suffering from terminal cancer and actually obtaining treatment, including hospice care, by falsifying medical records. Despite her claim that her cancer is in remission, the facts show that she was never diagnosed with cancer, and that she used the story to solicit tens of thousands of dollars through fundraisers on her behalf. Blue Cross Blue Shield is seeking over $100,000 in restitution in that case. These facts are necessary to review because under the sentencing guidelines, the minimum range for her conviction in this case is 0 to 17 months. As such, the case falls into the category of an intermediate sanction cell and requires the court, absent a departure, to impose a jail term of not more than 12 months, which is the recommendation. Given the facts in this case, such a sentence would be a grave miscarriage of justice. This isn't a situation in which someone falsely reports a stolen car. Had her allegations been charged and she perjured herself, she would have been facing life imprisonment herself. Even though these men were not charged, the accusations circulated around this small community, and they were unresolved until her convictions. If the totality of these facts do not establish substantial and compelling reason for a departure from guidelines, it is difficult to imagine what would. Nothing in the guidelines gives adequate weight to the diabolical nature, the methodical orchestrations, or the callousness of her treachery. She was willing to go so far as to self-inflict wounds, to corroborate her falsehoods, to carve into her forearm the word slut. She had no reason to falsely charge these men. Had they not had airtight alibis, a factual question would have been presented, and they most likely would have been brought before a jury. As with most of these cases, it would have been a case of one person's word against another. One could only speculate whether the truth would have come out. Also, Sara Ylen could play the victim one more time. The court finds that the sentencing guidelines are inappropriate in this case. required to attain the ends of justice. The premeditated nature of this crime is not adequately considered by the guidelines, nor is the extent to which she was willing to go to falsely accuse two men of a capital offense. Nor is there adequate consideration given to the guidelines for a person who has a history of making false charges of capital offenses or has the capability to commit massive frauds upon her community. Do not see this woman sent to prison for her crimes to be a travesty of justice. Sara Ylen, for the crimes that you committed before this court, I'm going to adopt the recommendation made by the prosecuting attorney. The charge of falsifying the report of a felony, you're sentenced to the Michigan Department of Corrections for a minimum term of 2 years to a maximum term of 4 years. The crime of tampering with evidence for felony punishable with more than 10 years, you're sentenced to a term of 3 years to a maximum of 10 years. And these terms are to be served consecutively. You are entitled to have both the sentence and the conviction viewed as a matter of right by the Court of Appeals, and you'll be given a form before you leave here that outlines those rights that your application for court-appointed counsel. And those you have retained counsel for trial, you need a court-appointed attorney for appellate purposes. That will be provided to you. Mr. Highbrook, for the next step forward. He is now given that form. You're required to return that to us within 42 days to have the attorney appointed to file your pending appeal. The standard statutory costs and assessments are included in the judgment sentence. That is included, and that's what the sheriff continues to the Department of Corrections.
Thank you very much, Your Honor.